Hi, good morning, or excuse me, good afternoon, everyone. It's now officially afternoon here in Mississippi. Good to see everybody. For those of you that may not know who I am, I'm Chad Allgood. I'm the director for the Division of Early Childhood Care and Development. Thank you all for joining our work group meeting. This is work group number 7, I believe. And what we're doing as part of this process uh, with these work group meetings. So a few weeks ago, we convened the two advisory councils that one of the advisory councils that works with the child care licensing program, which is part of the Mississippi State Department of Health, and then the Child Care Payment Program Advisory Council, which works with my division at Mississippi Department of Human Services to talk about the current language with our regulations governing child care programs in Mississippi, and there's also the overall program. And the two councils agreed to move forward with this project, and this project being an overhaul of the regulatory language and the licensing process itself. And so we talked about undertaking this project in 3 phases, which also the councils agreed to. So we are currently in phase one, and phase one involves us focusing on making sure that the framework of the regulatory language meets the federal requirements. Phase two, when we phase two, we will move into state specific language, so things that are specific to Mississippi. And then in phase three, we're going to focus on the administration of the licensing program. So the way that licensing visits are conducted, inspections, monetary penalties, the whole kit and caboodle as far as that's concerned. Um, so today we are going to be focusing on uh, the recognition, protection, and prevention of child abuse and neglect. And we have a work group that signed up to be um, to specifically help us target this topic. And so in a minute, I'm going to introduce them, and then we'll get into the meeting itself. So, joining me from my division, we have Lakeisha Bland, who is Lakeisha is our liaison with our licensing program, and then we also have Crystal Carter and Crystal Murphy, the two Crystals. They are also assisting with this project. It's a very large project. The scope of it is very wide, and then we also have members from the Mississippi State Department of Health that are joining us today to answer any questions as it pertains to the current regulatory language or to help clarify anything on that end. Because we are focusing on the federal requirements, we are also very thankful that we have our federal TA partners joining us just to help keep us on track, but also make sure that we're not missing any of the critical pieces associated with meeting those federal requirements. And today we have Jean Van Orstel that's going to be joining us. I'm going to turn it over to her in just a moment. She's going to be talking about the federal side of things, and then we'll get into the review of the federal language and actually getting feedback on how we can provide any clarification or make things easier to understand. Which leads me to the purpose of this whole project. All of these work group meetings, today's the ones before and future work group meetings, the whole goal of this project is to take the regulatory language, make things simpler to understand, make them easier to understand, remove any situations where there are contradictions in the regulations. We want the regulatory language to be to be helpful to our child care provider. We don't want there to be any question about what you all can do to help keep our babies and our kids healthy and safe. That's first and foremost what's important. We don't want there to be any aha gotcha moments. That's not what this is about. This is about clarifying everything and creating a set of regulations that you all can use as a guide for keeping our babies and our kids healthy and safe. That's the ultimate goal. And we want to make sure that we're getting direct feedback from our child care provider community because we want these regulations to work for you all. We want it to make sense. We want, like I said, we want them to be helpful. Before I turn it over to Jean, I just one other thing that I wanted to say. Those of you that may not have joined us before, you may be wondering why Department of Human Services is even is involved with this process. So what I wanted to just explain is that yes, the child care regulations are under the purview of the Mississippi State Department of Health. However, the Department of Human Services, which is the agency that Lakeisha, the two Crystals, we're part of, we are the lead agency for the Child Care Development Funds program. And as the lead agency, we are required to make sure that the monitoring of child care programs for health and safety requirements is being done. And we have a contract and a partnership with the Mississippi State Department of Health, but ultimately we are the agency that is responsible to our federal partners, making sure that those activities are taking place. Also, something just to point out is that the child care licensing program is funded through almost exclusively through CCDF money through the contract that MDHS has with the Mississippi State Department of Health. So today, the way that it's going to go here in just a minute after, like I said, Jean's going to do an introduction on the federal side of things, and then we're going to dive into the specific language for the regulations. So to just in the interest of time and moving through the content without getting bogged down too much, we want to be mindful and respectful of everyone's time. We do ask that during the first part of the meeting, when we're diving into the language, we do want the members of the work group, and I'm going to do a quick roll call here in just a minute, but we really want the members of the work group to do the talking during that point. When we finish the walkthrough of the regulatory language, we are going to have a public comment section. So any of you that are not members of the work group or one of the members that I'm about to, when I take roll, you are more than welcome to give feedback when we get to the public comment section. And please provide any feedback that you have on anything that we talk about today. Just a reminder that today is about solutions. We're working on fixing things that maybe need to be fixed. So I'm going to do a quick roll call. So the members of the work group, when I call your name, if you'll just come off mute and if you'll just say here or present, just to let us know you're here. Lynn Black.
Here.
Hey, Lynn.
Hey.
Thanks for joining us this afternoon. Michelle Connolly.
Here.
Hey, Michelle. Thanks for joining us today. Nancy Sylvester.
I'm here.
Hey, Miss Nancy. Thanks for joining us today. Matt Williams.
I'm here.
Hey, Matt. Thanks for being on. We appreciate it. And from Department of Health, Jamaria Davis.
Hi, Chad.
Hey, how are you today? Thanks for joining us.
Good. How are you?
We appreciate it. Okay, so those are our work group members. Like I said, during the first part of the meeting, we're going through the language. They're going to be giving the initial feedback. And then, like I said, when we get to the public comment section, anyone that is not part of the work group, please feel free. We'll give you the opportunity to give us feedback. So again, I just want to thank you all for being here. Thank you for taking this process seriously. Thank you for joining us for this project. I know it is, there is a time commitment associated with undertaking this project, but I do feel that it is going to be time well spent. So with that said, Jean, I'm going to turn it over to you. Thank you.
Thank you, Chad. I appreciate it. I'm going to take just a moment to introduce myself. My name is Jean Van Orsdal. I am a lead technical assistant specialist with the Child Care Quality and Business Support Center. I have been doing federal technical assistance now for 18 years, and my subject matter of expertise is in health, safety, and well-being. So this is a perfect fit for me to be on today and just support you with this work. So Chad already provided our welcome. So if you've attended another advisory group meeting, you will recognize this agenda flow. We start today with an overview of the CCDF requirements and the topic we're reviewing today. And then I'll pose some questions to you all for you to consider as we move through the review. We will wrap up with 2 different discussion opportunities. The first is a rule discussion for the advisory group members, as Chad mentioned. And then once that discussion is complete, we will open the floor for any public comments. If you are not a committee member, you may want to take notes. I know I would, on your thoughts or comments so you can have them ready for the public comment portion of the meeting. So when we talk about the Child Care and Development Fund requirements specific to health and safety, we like to think of them as a 3-legged stool. The first leg is the standards or regulations, and this leg requires the development of standards based on health and safety topics, as well as requirements for staff to be trained. The second leg is training. There are 2 parts to this. The first part references training on the health and safety topics plus child development. And this is called the pre-service or orientation training. The second part of the training includes ongoing training and professional development for staff. The third leg is monitoring. Programs must be monitored to ensure that they are implementing the standards and regulations as well as completing the training. Today, we're going to focus on the first leg of the stool, the regulations. So this slide outlines the 11 CCDF health and safety topics that states must address through regulations or standards for child care programs. Today, we are focusing on topic 6 and 11, which are highlighted in bold on this slide. But let's break this down a little bit. So here's the 11 health and safety topic areas, and each lead agency shall certify that there are in effect within the state or other area served by the lead agency under state, local, or tribal law requirements appropriate to provider setting and age of children served that are designed, implemented, and enforced to protect the health and safety of children. Such requirements must be applicable to child care providers of services for which assistance is provided under this part. Such requirements, which are subject to monitoring pursuant to Federal Rule 98.42, shall include the health and safety topics consisting of, and you can read these on the slide. We've got infectious disease, prevention of sudden infant death, administration of medication, prevention and response to emergencies, building and physical premises safety. One that we'll talk about today, prevention of shaken baby syndrome, abusive head trauma, and child maltreatment. Additional topics include emergency preparedness, handling and storage of hazardous materials, transporting children, pediatric first aid and CPR, and another topic that will be covered today is recognition and reporting of child abuse and neglect. So those are the topics that we have to cover, and states must cover those, but they also may include requirements related to nutrition, access to physical activity, caring for children with special needs, or any other subject area determined by lead agency to be necessary to promote child development or protect children's health and safety. Include at minimum health and safety training on the topics above as described in 98.44 plus child development. So all of these we have to have standards on, and in addition, child development, we need to add the training. So lead agencies must establish standards to protect children's health and safety, including the prevention of shaken baby syndrome, abusive head trauma, and child maltreatment. Abusive head trauma and shaken baby syndrome are a type of child maltreatment. Examples of standards for the prevention of shaken baby syndrome include standards for coping with crying or a fussy infant, prohibiting corporal punishment, and supporting an infant's head when lifting. Standards also must be in place regarding the recognition and the reporting of child abuse and neglect. Child abuse and neglect have long-term impacts on child's health, opportunities, and well-being. The most well-known types of abuse include physical abuse, sexual abuse, emotional abuse, and neglect. States, territories, and tribes, through their child welfare system, are responsible for determining their own definitions of child abuse and neglect. Lead agencies are encouraged to use their child welfare agency's definition of substantiated child abuse for consistent reporting across programs. So let's break this health and safety topic area into two parts. Not only do we need to address recognition, but also reporting. Recognition due to the impact that child abuse and neglect can have on children. It is important that caregivers, teachers, and directors of CCDF providers are aware of and can identify the common physical and emotional signs and symptoms of child abuse and neglect. Second part is reporting. CCDF rule requires child caregivers, teachers, and directors of CCDF providers to comply with the state, territory, or tribe's child abuse reporting requirements and other child abuse reporting procedures and laws in the service area. Through this rule, CCDF requires that caregivers, teachers, and directors are mandated reporters of child abuse and neglect, whether or not the state, territory, or tribe explicitly identifies these persons as mandatory reporters. Therefore, your standards must include this reporting requirement using the method prescribed by your state, territory, or tribe's child welfare agency. So the types of indicators for each of the topics, I've identified some of these, but we're looking at prevention of shaken baby syndrome and abusive head trauma and child maltreatment. We're looking for things like prevention policies, recognizing, responding to, and reporting the signs and symptoms of shaken baby syndrome and abusive head trauma, strategies for supporting staff members, appropriate discipline and guidance techniques, and for recognition and reporting of child abuse and neglect, the importance of identifying the common physical and emotional signs and symptoms of child abuse and neglect, and compliance with the state's child abuse reporting requirements. We will work through specific regulations from these rule sections as part of our discussion today, noting that there may be additional rules in other sections that are related, but will be addressed during future conversations as part of Phase 2. So here are some questions to consider as we think about each of these rules during the discussion today. The first question: does a particular rule present a challenge in how it is worded or written? Are there specific rules that you feel are repetitive or could be combined or condensed? If so, can you describe which rules What changes or improvements would you make? Are there specific rules that you struggle with or find difficult to implement? If so, can you describe which rules? What changes or improvements would you recommend to make them easier to follow? Are there rules that you find are confusing? If so, can you describe why? What changes or improvements would you recommend to make them clearer? Do you have suggestions for rule changes to help ensure high-quality childcare and reduce the burden on current childcare providers for new or potential childcare providers? And finally, do you have any other suggestions or feedback you would like to share regarding the rules? Are there any questions at this point about the CCDF requirements? Okay, not hearing any. We're going to go on to the rule review discussion, and I'm going to turn the mic over to Crystal.
Thank you, Jean. Good afternoon. My name is Crystal Carter, and I will be your facilitator for today's work group on child protection, prevention, recognition, and reporting of abuse, neglect, and maltreatment. We will review each rule individually. As each rule is presented, we will pause for questions, comments, or suggestions for revisions. Are there any questions at this time?
No, ma'am.
Thank you. Let's begin. Item number 1, prevention of shaken baby syndrome. I'll wait till you get it up. Okay. Item number 1, prevention of shaken baby syndrome and abusive head trauma. Rule 1.48, prevention of shaken baby syndrome and abusive head trauma. Each child care center licensed to care for children up to 5 years of age shall develop and adopt policies to prevent shaken baby syndrome and abusive head trauma prior to licensure. The policy shall include the following. Are there any questions or comments about this rule? Item number 2, Rule 1.48. Number 1, how to recognize, respond to, and report the signs and symptoms of shaken baby syndrome and abusive head trauma. Signs and symptoms include irritability, difficulty staying awake, difficulty breathing, inability to lift the head, seizures, lack of appetite, vomiting, and bruises. Are there any questions, comments, or concerns about this rule? Okay. Item number 3. Number 2, strategies to assist staff members in coping with a crying, fussing, or distraught child. Are there any comments, questions, or concern about the rule? Item number 4. Number 3, strategies to assist staff members in understanding how to care for infants. Are there any questions, comments, or concerns about the rule? Item number 5, number 4, strategies to ensure staff members understand the brain development of children up to 5 years of age. Are there any questions, comments, or concerns about the rule?
I have a question, and although that number 4 is extremely important to have that understanding of brain development, but in how does that correspond with the overall part of preventing the shaken baby syndrome? Just curious if it goes together or has a direct correlation. It's important, but just wondering if it has a direct correlation. That's all.
Hey, Michelle, I don't know if it's a direct correlation. I think it's just with the whole thing about shaking baby and helping them understand brain development and how that can impact brain development in general. So
Perfect. I agree.
So Keisha, I wonder if we should add that to just to clarify that it is in the context of the importance of protecting babies' brains during this critical time.
okay.
I don't know. What do y'all think?
I don't think it would hurt.
I think it's a good idea.
I think that's fine.
And
Like you said, just adding a little more context.
I have a question, and what would some examples of strategies be? Not that I'm suggesting to list those out in the policy, but just to understand the context of this policy and how it might be interpreted.
You talking about still on number 4, Matt?
Yeah, number 4. So if we say strategies to ensure staff members understand, what would some of those what would examples be?
I mean, to me, it's training. I mean, it's just
Training.
educating. I think it's just educating. Maybe we could just even say something around provide education to staff members so that they understand the brain development of children, and then the context. Maybe be more specific. Would that make more sense? Because I agree. Just saying strategies, it's a little okay. What is that?
Are there any more questions, comments, or concerns about this rule? All right. Item number 6. Number 5, a list of prohibited behaviors that shall include, but not be limited to, shaking a child, tossing a child into the air or into a crib, chair, or car seat, and pushing a child into walls, doors, and furniture. And are there any questions, comments, or concerns about this rule? Item number 7, number 6, resources to assist staff members and families in preventing shaken baby syndrome and abusive head trauma. Are there any questions, comments, or concerns?
I think that can be combined with number 4, since we're going to be kind of rewording that to provide education. Instead of having them listed out 2 different times, number 4 and number 6 can kind of be combined into one.
I think that's a good idea.
Are there any more concerns about the rule? Okay. Item number 8, prevention of child maltreatment, subchapter 14, discipline and guidance, rule 1.14.1. Prohibited behavior. The following behaviors are prohibited by anyone, i.e., parent, caregiver, or child, in all child care settings. Are there any questions, comments, or concern about the rule?
I would add director in there just to protect them. I know it's not it's not a list that's complete, but I still think they need to be in there to protect them.
Good point. But they might not consider themselves a caregiver.
I would think that they are a caregiver, and they definitely
Right.
do, but somebody who works under them is going to call them a director.
Uh-huh. Yes, yeah. Cover all bases.
Any more concerns or suggestions? All right. Item number 9, number 1, corporal punishment, including hitting, spanking, beating, shaking, pinching, biting, and other measures that produce physical pain. Any questions or concerns about the rule? Item number 10, number 2, withdrawal or the treatment of withdrawal of food, rest, or bathroom opportunities. Any questions, comments, or concerns about the rule?
Crystal,
Yes, ma'am.
I'm sorry. Let's go back to the shaking, pinching, biting. I think, is it that one?
Item number 9.
Um, I think it's 9. But I was going to say too, we need to take into consideration, and I don't know because I've seen this happen a couple of times where you have teachers that have these long fingernails, and sometimes those long fingernails, not that they're trying to scratch them, but if they reach out to get them, you know, and those nails have, I've known and I've seen it happen. Nobody was just trying to grab them, but we need to try and it's something that I am going to implement here, that their nails are, not that you're telling people how they need to look, but I know on some of that scratching and people say, oh, they pinched me, but they didn't pinch him. But you know how you reach out to grab a child and you have those long nails and it'll leave a mark on them. And I think that should be mentioned in that too, about those long nails.
Okay.
And I also want to see on that under the corporal punishment, should we say including but not limited to? Because I have heard of situations to where centers try to, oh, they didn't hit, spank. If you use another word besides one of those specifically in there, they try to say what it didn't happen. So I'm wondering, should that be a little more inclusive, because it wouldn't cover things like the nails. or saying like, for example, or something like that. So it's clear that it's not just that this list is not all inclusive.
Thank you, Ms. Lynn and Lakeisha. Are there any more questions or comments about the rule? All right, item number 10, number 2, withdrawal or the threat of withdrawal of food, rest, or bathroom opportunities. Any questions, comments, or concerns? Item number 11, number 3, abusive or profane language to include but not limited to yelling at and or using harsh tones toward the children or in close proximity, hearing distance to children. Any questions, comments, or concerns about the rule?
That's very wordy. Lots of ands and ors and commas, and it's very wordy. I think I don't know how to simplify it, but I think it could be simplified just a little bit better.
Okay. Thank you, Ms. Michelle. Item number 12, number 4, any form of public or private humiliation, including threats of physical punishment. Any questions, comments, or concerns about the rule? Item number 13, number 5, any form of emotional abuse, including rejecting, terrorizing, ignoring, isolating, out of view of a caregiver, or corrupting a child. Any questions, comments, or concerns about the rule?
What's indicated at are corrupting a child? What's being said there? I think that needs to be clearer.
Well, for example, I think we had a situation where we had a child care center that was holding Fight Club in one of their classrooms. So that's certainly corrupting, teaching children to say curse words, subjecting them to any kind of inappropriate material, pornographic material, etc. I think we could certainly clarify some of the things. No Fight Club. We could, certainly put that in there. Put that in there.
I was about to say, Chad, every one of these, there's a reason behind it, which, you have to sit back and go, wow, on sometimes.
Any more questions, comments, or concerns about this rule? Item number 14, number 6, use of any food product or medication in any manner or for any purpose other than that for which it was intended. Any questions, comments, or concerns? Item number 15, number 7, inappropriate disciplinary behavior includes, but is not limited to, putting soap or pepper in a child's mouth. Any questions, comments, or concerns about the rule?
Was an earlier rule that we covered that talked about the corporal punishment and what have you. Did it just say physical? The reason why this would be here, it just said corporal punishment. Okay. All right. I'm okay.
But I see where you're going, Miss Nancy. I mean,
Yeah,
does that
because
deserve its
yeah.
own, does that deserve its own number? I mean, or should it be included in where we were talking about other types of punishment? I think that's where you're going.
Mhm.
We could look at
I was thinking a similar thing, and just almost thinking that I kind of it up in that rule where we say other measures that produce physical pain. I was also thinking maybe adding or physical discomfort. You know, if what this rule is referring to is something that rises to the level of, you know, physical discomfort, that's maltreatment, but may somehow not be interpreted as physical pain, or if we need to get that into it. But I agree with my colleagues here.
we'll look at incorporating number 7 into number 1.
Item number 16. Rule 1.14.1, page 57, number 8. Any acceptable disciplinary action that is not age appropriate for the child or is excessive in time or duration. Any questions, comments, or concerns about the rule?
Again, I have another concern.
Yes, ma'am.
If it's acceptable, if it's an acceptable disciplinary action, but then it says that is not age appropriate. You're saying it's acceptable, but it's not age appropriate, so it's not acceptable. If it's not age appropriate. Is this kind of referring to something like timeouts?
That's what I'm thinking. It was talking about, and then we have another rule regarding timeout, because timeout is supposed to be, you know, technically they say 1 minute per age of the child, and so technically they say you shouldn't do timeout before a child is 3, and so giving a infant or toddler timeout, or giving a 3-year-old a 30-minute timeout, would be considered excessive. So we can look at making that a little clearer, because it's kind of saying it's confusing the way it's worded a little bit. I agree, Ms. Nancy.
Any more comments or concerns about this rule? All right. Item number 17. In a prior draft rule, notes a prior version of draft rules also included on 9th regulation under this section that reads as follows. Number 9, any prohibited behavior that shall include but not be limited to shaking a child, tossing a child into the air or into a crib, chair, or car seat, and pushing a child into walls, doors, or furniture. Any questions, comments, or concerns about the rule?
Based on previous conversations, I think we could still look at how that can be incorporated into the first one. It was different examples. It goes back to the shaking baby. I think it was just trying to make sure that was included specifically. But we probably could either join it with number one or at least move it up closer. So all that's in the same, whether it's a
Yeah.
same number or like a A, B with examples. What do you guys think?
Agree. I mean, because this list can continue to grow and grow and grow and grow and grow as people become a little bit more creative in the way they do this.
Right.
So we really need to think of some very strong verbiage. Yes, put some examples in there, but some very strong verbiage that will incorporate things that we can't even fathom, unfortunately.
Item number 18, Rule 1.14.2, restraint of a child, pages 57 through 58. Children shall not be physically restrained except as necessary to ensure their own safety or that of others, and then for only as long as is necessary for control of the situation. Children shall not be given medicines or drugs that will affect their behavior except as prescribed by a licensed physician and with specific written instructions from the licensed physician for the use of the medicines or drugs. Any questions, comments, or concerns about the rule?
I hate to keep saying things, I'm sorry, but there are times where you do want them restrained, right? And I'm not in, I mean, when they're in their bouncy seat, they need to be safely restrained. When they're in their car seat, they need to be safely restrained. So, I mean, I don't know if number 18, children shall not be physically restrained for, I don't know, maybe just clarify that there are times that they should be, and then there are times where when you are, lack of better words, I hate to say punishing a child, that restraint doesn't really need to happen unless they're harming themselves or others.
I think that's a good idea. Like you say, we want to make it as clear as possible. So, like you say, there are times when children do need to be properly restrained. So, clarifying that out would be good. Thanks, Michelle.
All right. Any more comments, questions, or concerns about this rule? All right. Item number 19, Rule 1.14.3, timeout, page 58. Timeout that enables the child to regain self-control and keeps the child in visual contact with a caregiver shall be used selectively, taking into account the child's developmental stage and the usefulness of timeout for the particular child. Timeout means that the child is given time away from an activity which involves inappropriate behavior. Isolation from a caregiver is not acceptable. Timeout is not allowed for children younger than 3 years of age. Any questions, comments, or concerns about the rule?
Just look at the wording where the timeout means that the child is given time away from an activity which involved inappropriate behavior. It reads almost like the activity. I don't know, maybe I'm reading that wrong. But it says an activity which involved inappropriate behavior. It's activity on the part of the child. I don't know. I may be reading it wrong.
I see what you're saying, Ms. Sylvester. The wording of it is not, it can be clear.
Is it sort of timeout means that a child is given time away from an activity due to inappropriate behavior? Is that sort of
Mhm.
Yeah,
That would be more in line, yes.
I see what you're saying. Yep, I see what you're saying.
Any more questions, comments, or concerns about the rule? Item number 20, Rule 1.14.4, children shall not discipline other children, page 58. Children shall neither be allowed nor be instructed to discipline other children. Any questions, comments, or concerns about the rule? Okay. Items numbers 21 and 22 will not be addressed during today's meeting as they were thoroughly reviewed during yesterday's child development training work group session. Based on the feedback and recommendations received, revisions will be made before these items are presented for further review. Item number 23, recognition of child abuse and neglect orientation. Rule 1.6.4, personnel records, pages 24 through 25. Number 1, employee records. Each employee's personnel record shall contain the following. G, documentation of orientation within 1 week of being hired, including but not limited to emergency procedures to include policies for handling dangerous situations, staffing and supervision requirements, daily schedules, physical, emotional, developmental problems of children, discipline policies, and child abuse and neglect. Are there any questions, comments, or concerns about the rule?
I have a question.
Yes,
I know
ma'am.
we received information where we had to do a DocuSign, and in there it said orientation within 90 days. And so I know here it's orientation within 1 week, and I know that's the center's orientation. But if that orientation in 90 days that's required, should it be included in here in clarity what the difference is in the 1 week orientation and the 90-day orientation?
Yeah, we can look at that because I think the other one, the 90 days, is the actual training, and this is more so just the center's policy. So yeah, we can make sure we clarify that, Ms. Nancy.
Y'all, I just don't like this word. And there may be a better word, but this word may be there for a reason. But I just don't like the physical, emotional, developmental problems of children. I think there could be a little bit a better word than problems.
Okay. We can look at some other language and even get the our federal partners to give us some suggestions.
Are there any more questions, comments, or concerns about this rule? Item number 24, reporting of child abuse and neglect. Rule 1.7.2, child abuse, page 29. Any operator or employee of a child care facility who has suspicion or evidence of child abuse or neglect shall report it immediately to the Mississippi Department of Human Services in accordance with the State's Youth Court Act, Appendix 8. Note, Appendix A that is referenced in rule is on pages 81 through 82. Any questions, comments, or concerns about the rule?
Does Appendix A include the hotline that they can call to make the report?
We can check that, but this also needs to be updated because it says that we reported immediately to the Mississippi Department of Human Services, but actually is Mississippi Department of Child Protective Services. So this needs to be updated in general because it's not reported to us anymore. It's actually reported to CPS. But we'll look to see if the hotline number is in that as well, Ms. Nancy.
Any more questions, comments, or concerns about this rule? Item number 25, subchapter 24, hourly childcare, Rule 1.24.10, abuse and neglect reports, page 74. Number 1, all employees will be informed by the hourly child care facility director of the individual's responsibility in reporting suspected abuse and neglect. Copies of the abuse law shall be provided to each employee. Appendix A.
I have a question there for Appendix A about the copy of the child abuse law. Is it still the same? If my memory serves me correct, I think that there have been like some changes. And if so, and memory serves me correct, I think there has been a couple of things changed in that. So because what I do, and this is just me, when I do my orientation and talk with my staff, when I go over this particular thing, I'll also have them to sign an NDA and have it notarized. But the last time that I looked, I had to go back and I think I had to make a couple of changes. So would that be the current?
We'll make sure that the copy that's in the appendix is the most updated version of the reporting requirements.
Any more questions, comments, or concerns about the rule? All right. Item number 26, number 2, reports of suspected child abuse or neglect will be made to the Mississippi Department of Human Services and or local law enforcement officials in accordance with state law. Because abused or neglected children require immediate attention are often identified after traditional business hours of the Mississippi Department of Human Services. Reports of this nature shall also be made to local law enforcement.
Again, that needs to be updated because the reporting information is incorrect.
Any more questions, comments, or concerns about this rule?
I have
Now-
a quick question because I haven't seen the updated enforcement law. Is there an and or does it always have to be reported to CPS? Yes, you do it to the law enforcement after hours, but do you have to turn around the next day and do it to CPS? Is there an and or option? I don't know the answer to that.
We'll look into that because I know CPS does have that 24-hour hotline.
That's what I thought too.
So it's like I think that was more when it was DHS. That may be kind of irrelevant. It may be depending on the nature of the abuse, whether it needs to be reported to the police, but we will look at that language and clarify it. Thank you, Michelle.
Okay, and then this is a little bit wordy also. But I had a case a couple of years ago, and I was told that even though that report was made to CPS, that I had to contact the health department and notify them, my licensure person, that that abuse had occurred.
I think that may fall under the serious occurrence reporting, depending on what the situation was, Ms. Nancy. 'Cause I do know they have reporting requirements if a serious occurrence, and the child abuse does fall under that arena. Isn't that right, Jamiria?
Yes.
So it wouldn't be necessary to put it here because it was actual abuse that occurred with the child.
It
And
may
I
be a good
didn't,
idea to add it, Ms. Nancy, like you said, because we have it, I think, under serious occurrences, but it, like we said, some things having it in there a couple of places, because if we're talking about reporting child abuse, making sure that they know everywhere that they need to report it, it's probably a good idea.
yeah, because we know you have to report to CPS first in our law enforcement. But
Right.
if it's necessary to also report to licensure after the reports have been made to them, I feel like it needs to be in there. Because when you read
Agreed.
this, you wouldn't think that you had to report it necessarily
Right.
to the health department. And I didn't, but when they came out to investigate, it was a whole different ball game. So that may be something to consider.
I agree. Like you say, anywhere that needs to be reported, I think it needs to be clearly outlined in this section. Plus, like you say, trying to make this not as wordy, even if we have to bullet it out, so it's a little bit clearer. But we'll look at both of those suggestions.
Any more questions, comments, or concerns about this rule? All right. Item number 27, number 3, hourly child care facility operators and/or directors are encouraged to establish a working relationship with local law enforcement authorities and the Mississippi Department of Human Services. In extreme situations where local county Department of Human Services staff cannot be reached, operators and/or directors will report to the statewide 24-hour child abuse hotline at 1-800-222-8000. Any questions, comments, or concerns?
It's the same. We're gonna have to update the language.
Yes, ma'am.
This is me being ignorant again, but I'm just asking. Like on number 25, it says, under this, third column, it says subchapter 24, hourly childcare, and then it says it again for 26, it says it again for 27, and again for 28. But then when we come over here, some of the current rule text writes out hourly childcare and some of them don't. And I don't even know what hourly childcare, the difference between hourly childcare facility and a regular facility would be. So this is just me not knowing. If it's important that hourly childcare should be in each one of those current rule texts, they're not. They're in some and not others. But if it's not important, because we're talking about all facilities, then we need to take them out of some like they aren't in others.
Okay. Good point. Thanks, Michelle. We'll look at that to make sure the information is consistently put in there.
Okay.
Any more questions, comments, or concerns about this rule? Item number 28, number 4, operators and/or directors will work in conjunction with the local law enforcement and the Mississippi Department of Human Services to establish a workable procedure for reporting cases when a child has been left at the hourly child care facility for an extended period of time after business hours, or when allowing a child to leave the hourly child care facility will place that child at risk or in potential danger. Any questions, comments, or concerns about the rule?
Still the reporting language.
And then also that's saying work with them to have a workable procedure. And that's going back to each individual center, the way it's worded to me. That's going back to each individual center to have a workable procedure for reporting the cases when a child has been left at the center. I don't know if there should be an overall procedure that should be followed, just like you've done with reporting child abuse, a procedure that's established to say this is what you do if this child is left at your center after hours, or there's potential danger for the child that you may not release.
Okay. We can look at that. Ms. Nancy, thank you for that.
So kind of piggybacking off of what Miss Nancy says, I own one, and my workable procedure is just take that baby home with me. Does anybody approve my workable procedure, or is it just whatever I want? If it can't be an overarching umbrella like Miss Nancy says it should be, which I think it should be, but if it can't be, somebody needs to look at it and improve it, I would imagine, because somebody's solution may not be a good one.
Agreed.
Exactly.
I agree.
Any more questions, comments, or concerns about this rule? We have now completed the review of all rules. At this time, are there any work group members who would like to make a final comment or offer additional suggestions regarding today's discussion?
I don't know how important this is to include, but having worked in the school district for a number of years, and this is one of the areas that I work with as being director of counselors, we were always told by the judges to be careful what's written about an abuse case. Be careful about interviews in relationship to abuse cases with things that can be held in court. I don't know if we want to get into even including or mentioning anything like that, because a lot of people may not know how to handle a case, and they could potentially harm a case where the child could be protected because they may not know how to handle it. Because so many written statements, if they end up in court, could be harmful to the child, or not allow the courts to follow through with the person who has abused the child. So the documentation that a center keeps has to be kept in the proper manner in order for the case to go through, if there's a need for prosecution with the person who has abused the child.
That's a very good point, Mr. Bester, because I also took a training when you said about the interviewing process. Even though directors are trying to be helpful, we probably do need some guidance, whether it's a rule or in the guidance part, because in the training I went to, they said if a director interviews and they basically feel like the child has been tainted, that they won't take the case forward. So that is something to be cautious about in terms of directors trying to gain information. So having some guidance, whether it's a rule or guidance, I do think we need to look at that because that can impact, like you say, whether it goes to court and even what procedures are followed in terms of trying to get more information once something has been reported. So,
Right. That's why I tell my staff, if the suspicion is there, report it and let them find the details once it's been reported. And we don't deal with trying to inquire and research and do anything on our own. We simply make the report.
And Miss Nancy, I'm sure it's in Appendix A, but it's not in any of this terminology, which may be good terminology, which would kind of extend what Miss Fancy's saying is some more terminology about a good faith reporter.
Any more comments from the work group members?
I just want to say thanks to all of y'all for facilitating the session today. And I think just a general comment about this last section related to reporting. It seems like a lot of the changes are going to be related to updating language to reflect, the proper reporting channels, inserting Department of Child Protective Services, and then also kind of looking at how we can just sort of really clarify what are the reporting procedures, including breaking it down to, it's CPS, it's health, it's local law enforcement, and these kinds of situations. I think that would be really helpful. And there are some resources, I think, really good resources out there. I think to Nancy's point, and I think, and Debbie might speak to this, but there's some resources that she posted in the chat. So a lot of good stuff out there, to provide as needed. So thanks.
Thank you, Matt. All right. We will now open the floor for public comment. If you would like to speak, please raise your hand or put your name in the chat. Speakers will be recognized in order in which requests are received. All right, Ms. Debbie.
Well, those child care providers are some pretty dangerous people, aren't they? I don't see one suggestion or identification of abuse for a child that's been abused at home that needs to be reported by the child care provider to CPS. I don't see any of that. I just see how to nail a child care provider. Excuse me. But a court of law is going to take all of these things you just listed, including putting a child under the age of 3 in timeout, including yelling at a child, to conduct a criminal investigation, including law enforcement. What in the world is going on? I don't know who came up with all of these identifications. I have a feeling it was HHS. They tend to be a bit hysterical, but there has to be a way to determine what should be reported to CPS, what should be reported to law enforcement, that doesn't include poor judgment on the part of a caregiver that can be corrected by the child care director. Some things just require training by the child care director, and such as the timeout and the yelling and not restricting food, water, etc. That should be monitored daily by the child care director, and that's just a matter of training. Head trauma should be reported if it's done intentionally, but it should be reported if the child comes into your facility with a trauma, and that happens 9 times out of 10. I don't see one thing here directing providers on what to do. But let me tell you this. If you come to my business and think you're going to conduct an investigation for child abuse, you better have a warrant. Because if you don't, I will see you in court. That is a criminal investigation, and you are not going to march my employees off to jail for a simple mistake or judgment in error, particularly if I'm training one. And I'll tell you something else too. I had DHS come to my facility they had received an anonymous phone call from the ex-wife. Oh, no, excuse me, the new wife on the ex-wife, accusing her of having spanked the child. Now, we don't support corporal punishment. It is not legal in a child care setting. But the Supreme Court has ruled that a parent can do that as long as they spank on the buttocks. This woman wanted me to identify the child for her and let her come in and take that child to my restroom and pull that child's clothes down to see if she had any marks on her behind. And I said, do you have a warrant? Have you screened this complaint? Well, now, Miss Debbie, now we're not going to hurt her. We just want to check her. Aren't you going to? I said, well, the only way you're going to be able to do that is if you can get my big girl panties down first. As it turned out, once the investigation was concluded, it was the second wife, the new wife, who was upset about child support going to the first wife. It was all dismissed. But let me tell you, they didn't stop before they went out to Pillar Academy, and they did take that child, and they did pull her panties down, and they did check her, and she cried in front of her classmates because they did not screen. I don't see one question on here that asks, are you a client of this provider? Do you owe this client any money? Are you related to this child in any way? Are you the ex-wife? Are you the current wife? Are you the mother? Are you the stepmother? I don't see any of that. And let me tell you, I don't know if any of you watched the news last week. Did you see what happened to Pete Buttigieg? Absolutely obnoxious. I can tell you what, I see one lawsuit after another and everything that you've listed here. You have not contacted CPS to determine what they call or identify as child abuse worthy of investigation and reporting to law enforcement. And I suggest you do that before this is published, before this is adopted. I don't care what HHS says. They have oftentimes made many suggestions that are unlawful and not legal. This is serious business, very serious business, and it is weaponized oftentimes to retaliate against a provider or a child care caregiver. Before a report is made, abuse of the grossest kind should be established. That discipline policy, you have combined discipline policy with child abuse. That's what you've identified here. I would suggest that this committee this group stop right here and contact CPS and find out what they identify as child abuse and what the procedure is for contacting law enforcement. And if I ever have to testify on behalf of an innocent provider, I will remember this day. I'm sorry, but this is very serious and you've taken it very, very lightly. Common classroom mistakes in classroom management and in training untrained staff do not rise to the level of a report to law enforcement. This should be very clear, and it's not. It's wide open. This is Gestapo. This tells me just don't show up to work and don't deal with these children. That's what it tells me, because you could be arrested. Well, all I can say is you better have a warrant. And if you'll look at what I provided, there is a process for screening in and screening out. There are false reports made every day. If you did not see the story about Pete Buttigieg, you need to Google that and find out what happened to him last week. Thank you.
Thank you, Ms. Debbie. Would anyone else like to make a public comment?
This is Dolores Sewell. While listening at the meeting, I took the liberty of going online and looking up some information. And first of all, I have to somewhat agree with Debbie, really 100%, because I have had some things that were not substantiated, and DHS has come out. So number one, who are we responsible? What's the responsibility of who do we call? Do we call DHS or do we call Child Protective Services to come out? Because when we call, we get the people from the health department. Are they the one licensed to actually do this? Or is it Child Protective Services? That's my first concern. The other thing is Debbie said, substantiating what actually is child abuse and what is a concern, what is a lie. And we get that all the time. We have children upset because they didn't go outside. We've all kinds of things that happen, and we want to make sure that everybody be given the right information and understand the true definition and all the things that are listed as kinds of child abuse. Because in listening to you, I did see some broad things that could really, in your notes, could be put together and not in so many different categories to make it less. But the main thing is we have to make sure we get this one right, y'all. And I do think, as Debbie said, Child Protective Services, perhaps even the police department, whoever would be included in making these decisions, we need to get some information from them, even as to how the process works. So that if you're going to ask us to do something, we can do it right, because I don't want to be held liable for calling somebody about a parent and then find out later, based on the information that I received from the health department, I was wrong. We have to get this right. So I just do think that we need a little more research before this is even published, because we need not only documentation, we need to understand what the state says, because the state has some laws on the book to tell us some things to do and what's supposed to happen. But also, I wouldn't put past talking to a judge, talking to Child Protective Services, and making sure that when you do whatever you need to do, because I'm thinking, listen at this, that we're going to need some training. Directors are going to need some training. We just cannot read this and say, okay, we can take this and run with it. I can't. I'm going to need some training from some professionals to make sure that I do the right thing and I go to the right people, because I don't want to go to one agency and then I have 2 or 3 other agencies coming telling me something. I need to know exactly what my responsibilities are and what my liabilities are. Thank you.
Thank you, Ms. Sewell. Would anybody else like to leave a public comment?
Crystal, it looks like Lynn has put a note in the chat. Excuse me. Ms. Hollingshead has put a note in the chat.
Yes, ma'am. Ms. Hollingshead?
Hello, thank you. I just have a question about access to children. And Debbie mentioned something about this, like they need a warrant, but we had a situation where someone made a report to Child Protective Services, and it was not anybody affiliated with my program. It was, I'm not sure what the connection was. I don't know who made the report, but I know it wasn't anybody with us. So the investigator showed up and wanted access to the child, but like I knew nothing about it. So like, does CPS have access to any child at any time? Like, I don't know legally what my rights are there.
On that, Lisa, I would suggest you contact an attorney, because even with the regulations, anything like that you have a legal question about, you're going to need to consult your own legal representation to see what your rights or responsibilities are in regards to that. But we would definitely look at having some conversations with CPS to make sure that the information we're putting in the regulation aligns with their requirements and what they are requesting, so that the information can be accurate and line up across both agencies, to make sure it's in compliance with what the feds are requiring and what CPS states is required as well. I do agree we do need to make sure we do that before we update this information in the regulations, because there are things that could have changed. So we will do that.
Okay. Thank you so much.
No problem. Miss Debbie, you put your hand back up.
Yes, I just wanted to say the rules are clear. Initial screening decisions, the laws and policies in all jurisdictions specify the procedures for the initial response. So if they have not followed that, Lisa, you don't have to allow the access. And I don't think you're supposed to allow access of a minor child to be investigated outside the presence of their parent. I have not been given that authority by my parents, and I don't care who DHS thought they were. They better have a warrant, or they better have a sound screening in and screening out process, because I will challenge it.
Do we have anyone else that would like to make a public comment? This concludes today's work group session. Thank you all for your participation, engagement, and valuable input. The notes and recommendation from today's discussion will be reviewed and considered as we continue the rule revision process. We look forward to continuing this work at our next session. Thank you all and have a great day.
Thanks, everybody.